think, thanks, Michaela. Um, I think lots of people on the call probably know me already or have worked with me at Ignition, but for those that don't know me, I'm Nicky Cranfield. I'm the head of the employment law team at Ignition. And today we're going to talk through some of the key provisions from the Employment Rights Act that are really relevant to SMEs. So thanks all for joining. There should be time for questions at the end, so please do ask any questions that you have if you'd like to. So this time last year, we were giving a webinar on the Employment Rights Bill and the provisions that the kind of government had proposed at that time. For those that kind of have followed the progress of it, you'll know that there's been lots of changes as it went through the various stages of Parliament. And eventually, the Employment Rights Act came into force in December last year with a variety of kind of last minute amendments before it did finally get passed into law. So today we'll cover the key updates for SMEs. There are a whole swathe of updates that this legislation brings forward, and lots of them won't be entirely relevant to the SME sector. So, for example, there are lots of changes around trade union law and some changes around collective consultation for redundancies, and I'm not planning on covering those changes today. If people do have questions on those, please feel free to drop me a line. Very happy to kind of talk to those another time, but today we'll be focusing on the changes that I would say are more key for the SME community. In terms of structure, whilst the Act itself came into force in December, the various provisions have different implementation dates. So what we'll do is we'll take a run through the various provisions that are coming into force in date order, so to speak. So first, if we look at the timeline, we've got some provisions coming into force in April this year. So we'll touch on those first. We've got more coming in autumn later on this year. So I'll also touch on those. Then in January next year, we've got what I would say is the biggest and key change around the unfair dismissal qualifying period being reduced and the removal of the cap on the unfair dismissal compensatory awards. And then beyond that, into 2027 and further, there are also other various provisions that will come into force. As we get further down that timeline, the detail available around those changes becomes less available because lots of them are subject to further regulations which will need to be brought into force. So we'll touch on them, but we won't have the detail for all of them. So for some of these things, it's just something to be aware of that it will be coming in the future and more detail to follow. But firstly, the April 2026 changes. The first ones to talk about are around paternity leave and parental leave. So the current provisions that are in force, we do have some in force for paternity leave and parental leave. For parental leave, each employee has an entitlement to 18 weeks of parental leave, which is unpaid and can be taken up to their child's 18th birthday. For paternity leave, there's 2 weeks for new fathers or partners. But each of those types of leave are subject to a qualifying period of service. So if somebody wants to take paternity leave, they have to have worked for you for 26 weeks. If they want to take the unpaid parental leave, they have to have worked for you for at least a year. In April, that's changing, and both of those entitlements to leave become day one rights. So any new hire has the ability to take that type of leave straight away. For parental leave, it's unpaid anyway, but for the paternity leave, there is still a service requirement in relation to the pay that attaches to that, but the leave itself can be taken straight away. So in terms of kind of practical impact, it will be to look at if you have policies and procedures in place in relation to these types of leave, they will likely need to be updated because they'll currently talk about the qualifying service requirements and that won't be in place in future. So one to take a look at and update as needed. Secondly, in April, we've got statutory sick pay changes. So the current position is that statutory sick pay is only payable from day 4. So there are 3 waiting days where an individual won't have any entitlement to statutory sick pay. From day 4, it will start to be paid. And the change is that those 3 waiting days drop away and statutory sick pay is available from day 1.
Yeah.
Also, there's currently a lower earnings threshold, meaning employees earning below a certain amount aren't entitled to statutory sick pay at all. Now, everybody will be entitled, and those that earn below the threshold will receive 80% of their weekly earnings. So, in terms of implications, if you've got a workforce that is only paid statutory sick pay from day 4, then clearly the potential for increased costs. But in reality, many employers pay from day 1 anyway. Many employers top up company sick pay on top of the statutory sick pay and is that which is also paid from day 1. So it may be that the practical impact isn't there in your organisation if you're paying that sick pay anyway already on a discretionary basis. What might need to be looked at and what might need to change is contracts and policies if they go into the detail and talk about that 4-day waiting, that 3-day waiting period, and SSP only starting on day 4. Some policies and some contracts will have that level of detail in, and that will need to be updated. Others just talk about an entitlement to SSP. In that case, there's no need to update because the entitlement remains. It's just how that entitlement is used in practice, which is changing. So some things to check around contracts and policies there. The next update for April is a change to the qualifying disclosures in relation to whistleblowing. So currently, to bring forward a whistleblowing claim, an individual has to make or be able to show that they've made a protected disclosure, and that protected disclosure has to relate to what is called a relevant failure. And the legislation sets out the things that can be classed as relevant failures, things like breach of health and safety or a breach of a legal obligation. Those are the things that can amount to protected disclosure. The change that's happening is that the Employment Rights Act 2025 will add a specific new element, which is sexual harassment that has occurred, is occurring, or is likely to occur as a relevant failure for the purposes of the protected disclosures in the whistleblowing legislation. In reality, it's a limited practical change because likely if there was even now under the current law, if there was sexual harassment that had taken place, it's likely to fall within one of the other heads of relevant failure because it's likely to be a breach of a health and safety requirement or it's likely to be a breach of a legal obligation by the employer. So it's showing that there's an emphasis being put on this sexual harassment and that it's being made clear by the government that this is an area where they're exploring and they're tightening up on. And again, there's further changes that will come in the autumn period and we'll touch on later. So it's one to be aware of. In practice, limited change, but definitely one to be aware of in terms of direction of travel for and where the government sees that importance in employees showing that they're aware of this, they're taking steps, they are making sure that employees are being protected from this type of behaviour. If you've got a specific whistleblowing policy and it sets out the heads of what the current relevant failures are, again, this is something that will likely need to be updated because we'll need to add that new element to those policies and procedures. Finally, in the updates for April is the Fair Work Agency, and this is a new enforcement agency that the government has established, and it will come into force on the 7th of April 2026. And the purpose of this is to bring together current enforcement bodies, and it will enforce things like, are people getting the correct statutory sick pay? Are people getting the correct national minimum wage? Are they getting the correct holiday pay? And holiday pay is also an area where the government is focusing more and requiring complete and full documentation and records of holiday pay and holiday taken. So once the Fair Work Agency comes into force and it was being rolled out on a phased basis, it will have quite wide-ranging rights to issue employers with kind of underpayment statements. So it could investigate on behalf of an employee and give an employer a statement to say holiday pay has been underpaid and therefore this employee needs to be paid X amount. So no need for that employee to go through an employment tribunal to get that. The Fair Work Agency can give that on their behalf. They can also bring employment tribunal claims on behalf of employees. They can assist employees with bringing claims. So it remains to be seen how this works in practice. It's obviously a new agency. It's bringing together things that have previously been there. But it's clear that the government is focusing on having a kind of more proactive and robust enforcement agency to kind of uphold these new employment rights that are being given to people. In terms of what to do now, definitely be aware that this is coming, this is happening, this new agency is going to be in force in April. Also, if there are concerns in your organisation around, has holiday pay been paid correctly? Is sick pay being paid correctly? Now's the time to do the digging, to do the audits, to kind of make those checks and try to get ahead of any of these things if they could become an issue. So that brings us to the end of the changes that are happening in April, and we'll move on now to those that are happening in autumn this year. So again, we talked about sexual harassment becoming a standalone kind of protected protection under the whistleblowing legislation. And again, there's further changes in relation to harassment that are going to come into force in October. So, firstly, as things currently stand, employers are not liable for third-party harassment. So, if a client harassed a member of staff, that the employer of that member of staff would not be liable. The change that is happening is the reversal of that situation. So, from October, the Employment Rights Act 2025 makes employers liable if a third party harasses their staff and the employer has failed to take all reasonable steps to prevent it. So this means that if a customer harassed a member of staff or a client harassed a member of staff, a contractor, the employer of that member of staff can be liable if they haven't taken all reasonable steps to prevent that harassment. And that's not just sexual harassment, that's any kind of harassment. The second part of the change is related specifically to sexual harassment. Currently, the law says that employers are required to take reasonable steps to prevent sexual harassment. And the update here is to kind of upgrade that. And the Employment Rights Act 2025 means that employers will need to take all reasonable steps. So moving from reasonable steps to all reasonable steps to prevent sexual harassment. And the impact of this is a raising in expectations of what's required. So it's no longer enough for an employer to do just one thing or something about these risks. Now, or from October, it will be expected that employers should be doing everything that's reasonably available to them to prevent this harassment happening. So, in terms of the third party harassment and sexual harassment more generally, it's going to be really key to think about the risks, the, the, the specific risks in your business. So, carrying out risk assessments, looking at your policies, thinking about workplace culture, making sure that employees, if there are policies in place, that employees are trained on them, they know that what there are clear instructions in terms of what um, complaint procedures there are, etc. And when you're doing carrying out risk assessments, once you've identified potential risks, trying to think about practical solutions to those. So, if you've got a situation where you've potentially got lone workers, is there a workaround to that where you've always got at least two workers together when going out to customers, for example, to try and narrow the risks that are there in that situation? The next change that's happening in October, or potentially happening in October, is an extension of the limitation period for employment tribunal claims. So currently, for the majority of employment tribunal claims, an individual has got 3 months from the date that they're complaining of to bring that claim. So for a dismissal claim, they've got 3 months from the date of dismissal to bring that employment tribunal claim. From October, there's going to be an extended period, so it's 6 months, which will allow the employee further time in order to bring that claim before it would be deemed out of time. So clearly there's an extended period of risk. And this, I think, as well ties into the Fair Work Agency because they also perhaps might need for more time than 3 months to assist, to work through, to check into these matters. So the 6 month period gives the individuals and the Fair Work Agency more time to explore claims. Um, the government's roadmap says no earlier than October 2026. So it could be that this date slips and it moves back, but as currently proposed, it's no earlier than October 2026. So when we consider this change, so an extension of the limitation period, with the other changes that will come into force from 2027 around changes to unfair dismissal eligibility and the removal of the compensation cap, it's all pointing towards a situation where it becomes easier and more attractive for employees to bring claims. So increased risk for employers, but also question how the employment tribunals are going to be able to cope with that, given that they're already under so much pressure. Um, I don't have the answer to that. I don't know how that's going to play out in practice, but on both sides, whether that's for the individual or the employer, already employment tribunals are struggling to keep up with the volume of claims coming through. So if that only increases, you can see that it becomes more and more unwieldy for individuals and employers to deal with that type of litigation. The next change that is coming into force in autumn this year is further information and clearer information for individuals about their rights to join trade unions. So currently, the law sets out that certain provisions must be included in employment contracts. So you must include the place of work, you must include the hours of work, you must include whether the employee is entitled to any training, you must include whether there are any collective agreements that apply to that employment. At the moment, there's no information required about trade union membership, but that's going to change under the Employment Rights Act 2025 because it expands these requirements of what needs to be included to state that there must be an explicit statement that the employees have a right to join a trade union. So at the moment, we don't have a specific set of words of how this will be need to be set out because the government is going to put in force further regulations which will set out that detail. What is clear is employment contracts likely will need to be updated because this statement, once we know its form, will need to be included. There is a school of thought that says it may be that this is a standalone statement. So, well, now we have sometimes a standalone opt out for the 48-hour working week that would be sent alongside an employment contract. It may be that this information about the right to join a trade union is also a separate standalone statement that goes out alongside any employment contract. Or it may be that that statement can be included in within the employment contract. But certainly it's expected that the government is going to be quite prescriptive about the form of words that can be used to make sure that this is clear to employees what this right is, rather than allowing employers to decide how to communicate that and potentially kind of slipping it in to a contract under the radar, so to speak. So whilst the specific detail isn't available yet, there will definitely need some updates to employment contracts or the way those employment contracts are issued alongside this statement come October time. Moving on now to January 2027 and the what I would say the absolute key and core change that this legislation is bringing in, which is around the extension of the unfair dismissal protection and the removal of the compensation cap. So the current law as it stands is that employees need a 2-year qualifying period to be eligible for unfair dismissal protection. And any compensation is capped at a maximum of 1 year's salary or around £118,000, whichever is lower. From January 2027, the 2-year qualifying period will be gone and there will be a 6-month qualifying period instead, and there will be no cap on the compensation limit. So, in terms of the implications, clearly the risks around terminations after that 6-month period increase drastically. Um, Now, within those first 2 years, provided that there are no kind of complicating factors, it is relatively straightforward to dismiss employees. But moving forward, the need for robust probationary periods and performance management from the outset is going to be more and more key. Because decisions need to be taken in quite a quick time frame if you want to avoid moving into a situation where the employee has unfair dismissal rights. So reviewing existing probationary processes and periods is going to be key now in advance of that change coming in to get managers and staff comfortable with that new process. Of course, for any employees who you already have, who have more than 6 month qualifying period in 2027, they will immediately have those unfair dismissal rights. So again, if you've got employees who have less than the 2 years, but in 2027 will have more than the 6 months, again, key to review their performance and progress now and make any difficult decisions sooner rather than later as needed. In terms of the probationary periods themselves, lots of contracts state 6 month probationary periods. And going forward, when this change comes in, 6 months is likely to be just slightly too long to give employers the flexibility they need. Because if you wait till the end of that 6 month period before dismissing, that individual will already have and be eligible for unfair dismissal rights. To my mind, you need to be looking more around the 5 month mark to be making any final decisions around probation, because that gives you some leeway. It builds in some timing safeguards if the employee's on holiday, if the manager's on off sick for a week or two, you still have some leeway there to be making these decisions and taking action before the end of that 6 month period. One thing to be aware of is that even if you're going to pay in lieu of notice, you need to make sure that any termination is at least 1 week before the end of that 6 month period, because the statutory provisions would add on 1 week of statutory notice to the date of any termination. So if you leave that termination date to any later than at least one clear week before, even if you pay in lieu and terminate immediately, the statutory provisions of adding the 1 week statutory notice would tip that employee over into getting the unfair dismissal protection. Hence why I'm saying think about 5 months rather than 6 months as your kind of end date for probation, so that it gives you a really good amount of leeway to deal with it before you're running up against those deadlines. Um, in terms of senior exits, they also become higher risk under the new legislation. At the moment, senior individuals on high salaries tend to be capped out in terms of unfair dismissal cases. So the risk reward ratio just isn't there for them to bring these type of claims, and therefore it's usually straightforward, even after 2 years of service now, to have kind of sensible conversations with senior executives around exits and packages that can be dealt with at a reasonable level because of this cap on the unfair dismissal compensation. Once that drops away, the employer's leverage is weakened in those situations, so it becomes much more important to have some formal process in place. Whether, it obviously will depend on the situation and why that senior person is being exited. But once there's no cap on the compensation limit, the leverage of that falls away, and it may become more attractive for individuals to litigate if they're also higher earners. They've perhaps got the capacity to do that. And the rewards are potentially there for them where they haven't been previously. So definitely one to think about in terms of the approach that the business takes to senior exits and how they're managed. And they will need to be a lot more thought through than they perhaps are at the moment. So lots to take in there in terms of that change to unfair dismissal, but certainly there are amendments that can be being made now to probationary periods and the way the business kind of looks at these things and works through these issues in preparation for next year and these changes coming into force. And the second piece that is changing in January 2027 is um, the end of fire and rehire. So really, this is all around an employer's ability to change terms and conditions. So currently, employers, if they can't agree a consensual change with employees around the terms and conditions, there is an option for them to dismiss those employees and then offer re-engagement on the new terms that are being proposed. Now, that's not illegal or unlawful at the moment, but it has been widely criticised for bypassing that consultation phase with the employees and bypassing the need to get them on board with whatever changes are coming into place. Um, ERA 2025 really kind of takes this a step further. There's already a statutory code of practice around how fire and rehire should be done in practice, but ERA 2025 makes it now automatically unfair to dismiss employees for refusing to agree to certain changes. So there are kind of two tiers of these types of changes. So for restricted variations, which are all related to pay or hours of work, which could again impact on pay. Um, any of those restricted variations, if an employer tries to push those through and an employee doesn't agree and there's a need to dismiss off the back of that, those kind of dismissals would be automatically unfair and there would be no qualifying period in relation to that. And the only exception would be if an employer could show that they were facing such serious financial difficulties that the viability of the business is affected. So it's a really high threshold to meet in terms of trying to find an exception to this rule that those types of dismissals would be automatically unfair. There are then a second tier of changes called unrestricted variations. So this is changes to place of work, to job duties, to restrictive covenants, that if an employee was dismissed off the back of not agreeing to those kinds of changes, they wouldn't be automatically unfair, but there would be a new statutory framework that an employment tribunal would have to work through to assess the fairness of those changes. So in terms of practical implications and steps to take, in my experience, most employers would prefer to bring their employees along on these on these kind of changes and have a quid pro quo type arrangement and offer incentives to the employees to make the changes that they want anyway. And that becomes all the more important. So to engage early with employees, communicate with them, explain the need for the changes, why they're going to happen, when they're going to happen, give a lot of notice for these changes. Um, Clearly, if significant changes need to be made to employee terms and conditions, it's going to be crucial to seek the proper legal advice in relation to those. For now, it will be important to check employment contracts, make sure that all your employment contracts have really robust variation clauses. Now, variation clauses aren't the kind of the golden bullet to getting rid of these new obligations, but they can help when used reasonably. So making sure that you do have a robust variation clause in your employment contract will help because then you're not seeking to agree the change with an employee. You're simply relying on your robust variation clause, which takes you out of this the remit of this legislation. So that's a must to check and make sure that you've got those in there. Beyond that, it's perhaps that dealing with managers and making sure that they understand that when changes need to be made, there has to be a really good consultation process, and employees do need to be brought along on that so that you can hopefully get consent from everybody to the changes. So those two things are to come in January 2027, and then there's a host of other things that are supposed to be coming after that. So throughout the course of 2027 and potentially beyond that. Firstly, there's new legislation around protecting new parents. So, as things currently stand, there is discrimination laws which protect against dismissal or detriment for pregnancy related reasons. We've got pregnancy related discrimination laws and sex discrimination laws which help in those circumstances. And there's also specific protection for new mothers in relation to redundancy and priorities for suitable alternative employment, but they are limited and very specific. The change that's going to come into force under the Employment Rights Act 2025 will require new regulations from the government. So we don't again yet have all of the information about that. We're waiting for those new regulations to see exactly what's being proposed. But in high level terms, there's a potential for a ban on dismissals during pregnancy or maternity leave, or for other related types of leave, adoption leave, shared parental leave, etc. So rather than having a specific limited protection, you've got a blanket ban on any dismissals in those circumstances, and then some limited carve outs. So, for example, we could see a situation where no woman who's pregnant or on maternity leave or returned within 6 months, for example, can be terminated at all, apart from in the case of a genuine redundancy or apart from in the case of a gross misconduct termination. We don't know exactly how that's going to play out and what those limited exceptions will be. But you can see in that scenario, if it was limited to those two things, if you had somebody who was underperforming, that would not be a fair reason for terminating that employee in that situation. That kind of termination for underperformance just wouldn't be permitted if that were to be the case, and that's what the regulations set out. So limited detail on that for now, but one to be aware of in the future that there will be further regulations coming in, and we'll get more detail on that as it progresses. Further changes to also come into flexible working. So at the moment, employees have the right to bring to request changes to flexible working up to twice a year, and employees have to respect that request and treat it in a reasonable manner. So, meaning that the process used around that request must be reasonable. Um, the change that's coming into force in 2027 is that as well as dealing with the request in a reasonable manner, any refusal of that request must also be reasonable. So at the moment, there's 8 reasons why an employer could refuse a flexible working request, and they won't change. They'll be the same 8 reasons that can be used. So whether that's added cost or detrimental impact on quality or performance or an inability to recruit to kind of backfill that role, etc. So those 8 reasons will stay the same. But at the moment, when an employer refuses, they can simply state the reason on which they're relying. Going forward, more will be required. There will need to be an explanation of why the employer is relying on that reason and why that's reasonable in all the circumstances. So, in my experience, most employers will even now give some explanation of why that reason is being relied on, not simply just state the high level reason. As things currently stand, it's not absolutely required that employees give that explanation going forward. Absolutely, that explanation will be required. Kind of side note on the penalty in relation to getting this wrong, it's 8 weeks' pay as a maximum for a breach of this obligation, which in the scheme of things isn't a lot, but often discrimination claims will be tagged on at the same time as complaints in relation to flexible working requests. So it often comes hand in hand with another type of claim. So again, it's one to be thinking about and making sure that managers get right, that they take these requests seriously and do actually look into whether it would be reasonable for the change to happen. Again, in terms of policies, if you have specific policies in relation to flexible working, likely they will need to be updated in due course to reflect these changes, and give that clarity to both employees and the managers handling them as to what's required. The next thing to touch on is bereavement leave. Currently, there's a right for employees to take parental bereavement leave of 2 weeks, and that's available to bereaved parents only. And there's no statutory right for any other employees to take any bereavement leave, although lots of businesses would offer this informally and on a discretionary basis. Um, at the moment, the parental bereavement leave of 2 weeks is paid at the statutory rate, which is £187 a week, and that the payment for that leave is subject to 26 weeks service as well. So there is that limited ability for employees, for bereaved parents to take bereavement leave, no statutory rights for anybody else to take bereavement leave. The change that's coming into force means that the right to take bereavement leave will be extended to all individuals. It's going to be 2 weeks, the 2 weeks for child loss will be maintained, and it's been put forward that for other bereavements, it will be an entitlement to 1 week, 1 week of leave. Again, in this respect, we're waiting for further regulations from the government. So we don't have the exact detail of which relationships will be covered in terms of those other bereavements and whether that leave will be paid or unpaid. But we do know that there will be at least some right to take that bereavement leave. Um, a note to look at policies. If you have specific policies around bereavement leave, again, they're likely to need updating. But beyond the policy documents itself, it's making sure that the managers who are dealing with these situations day to day are aware of these changes and know that this is an entitlement that employees will have. Ban on 0 hours contracts. This was kind of a headline term for the government when in its manifesto um, that they would bring in a ban on 0 hours contracts. And it's not quite a ban, what's being proposed, but it does make things much more complicated in this arena. So currently, 0 hour contracts are lawful, permitted, can be very flexible, used very flexibly by employers. Going forward in 2027 or potentially later than that, there's going to be changes in this arena. So guaranteed hours will need to be offered to those workers who are under those 0 hours contracts. There'll be a right to reasonable notice for shifts, and there'll also be a right to compensation if shifts are cancelled. All at the moment, very little detail around how this will all work in practice, and regulations will follow in this area. Now, if you don't have a 0 hours contract contracts or you don't employ low hours workers or employees, the impact of all of this will be very low. It won't affect your business if you don't have those types of contracts in place. If you do, then it's important to start the audit processes. You know, how many hours are your 0 hours contractors regularly putting in? Is there, or what is actually needed by the business? Do you need to get ahead of that and put some fixed hours contractors in place before the requirement to do this comes into place? Um, on the flip side, there's a school of thought that says that really these provisions are being very much kicked into the long grass by the government. It's a really complicated area and it's going to require very complicated regulations, and they've perhaps got more focus on other things. So whether this is something that actually becomes buried in the legislation and doesn't actually come into force, perhaps even during this parliament, it might go to the following parliament or never come into force at all. So there's a real question mark over when and even if these changes will come into place. And finally, the last change, which was kind of a late amendment to the Employment Rights Act 2025, excuse me, is a proposal for a ban on NDAs in discrimination and harassment cases. So the current law, with the current law, whilst whistleblowing legislation is held up and it's not possible to circumvent that legislation with confidentiality agreements, it is still possible to enforce some confidentiality obligations in relation to harassment and discrimination. For example, this can happen under settlement agreements. The new proposal is that there'll be a change in the law around those kind of non-disclosure agreements or confidentiality agreements, which would void any clauses that relate to work-related harassment or discrimination unless they are set out in an accepted agreement. Currently not clear what an accepted agreement will be. Question mark, will settlement agreements fall within the definition of accepted agreements? We just don't know yet because there's little detail and it needs to be refined by regulations before we can fully understand what this will entail in practice. But clearly, if settlement agreements don't fall within this definition of accepted agreements, we may have to start using a different form of agreement. Perhaps you might need two agreements. You might need your settlement agreement plus an accepted agreement if you need to waive that type of claim. So again, something to be aware of, not likely to be enforced anytime soon. This is kind of way into 2027 that it's being proposed that this would come into force, but one to kind of know about now, and keep an eye on for the future. And I think done a lot of talking, and that brings me to the end of what I wanted to say. So if there are any questions, please do feel free to shout now, or if anybody wants to drop me an email afterwards, I'm very happy to follow up.
Nikki, just one question from me on the unfair dismissal period. You mentioned
Yep.
5 months as recommended probation. That timeline essentially would mean that any extension to probation is not possible. Is that what I'm hearing?
So when I'm saying 5 months, Sky, I would say a lot of the time now, employment contracts say 3 months probation with an ability to extend for a further 3 months.
Hmm.
What my proposal would be is 3 months probation with an ability to extend for a further 2 months.
Got it.
because then you're giving, you're keeping the initial probation relatively short and reasonable, but you've given yourself that extra period up to the 5 months. The danger of leaving it and giving yourself the extension up to the full 6 months is that you kind of drop the ball in that last period and miss it, and it goes over into the person having the unfair dismissal rights. If it's very clear within your organisation that 5 months is the cut-off, it just gives you that leeway to deal with things.
Great. Thank you very much.
Okay.
Nikki, I just had a question. Thank you so much for that. That was really helpful, particularly where you kind of laid out the practical steps and changes for SMEs. Clearly, the changes are pretty sweeping and wide-ranging. Just wondering if you had a view in on what area there could be the most potential increase for claims and therefore is the biggest risk for SMEs.
I think it's really the mixture of different changes that are coming into force. So we've got an extension to the limitation period, so giving employees a longer period in which that they can bring a claim, so 6 months post termination. Plus, you've got a shorter qualifying period for unfair dismissal. So you've got more employees with the ability to bring that type of claim. And then on top of that, you've got the changes to the compensatory award cap with no cap going forward. So again, there's potentially, especially for higher earners, there's much more incentive and ability to bring those type of claims through an employment tribunal. So it's the three measures together for me that really kind of increase the risk. And as I said, it also puts the employment tribunals under a lot more pressure than they're currently under, and they're already struggling. So it then brings into question, how effective can those processes be for employees, but also for employers, because it could be that employers end up with claims hanging over them for a very long period of time if the tribunals can't get through those cases quickly enough.
Thanks, Nikki. That's really helpful.
Welcome.
Nicky, a quick question on the unfair dismissal compensation
Yeah.
and removal of the cap. Are we expecting guidance in due course on kind of bandings of compensation or when an award might go beyond the original cap? Or is it just going to be kind of completely at the employment tribunal's discretion?
So there are already kind of guidelines in place, not kind of written guidelines, but from case law, etc. So it's all about what is that person's financial loss. So there is an obligation on individuals to mitigate. So if you looked into the market and for that particular job role there were oodles of jobs available, well, the tribunal would say, oh, well, you could walk straight into a new job. Actually, your financial losses are very limited. But again, when we're getting to the senior end of the spectrum, obviously the jobs are going to become rarer and harder to move into. So it's easier for employees to run an argument to say, well, it is going to take me 12 months, 18 months to find a job and at an equivalent level. And now I'm not capped out at 118,000. My financial losses run into, my full 12-month salary or more.
Right. So the removal of the cap is more to sort of open this up to high earners or
Well,
senior executives.
that is the effect that it's had. I'm not sure that was the intention that
Right, okay.
is behind it. Yeah.
Thank you.
Any more for any more?
I was thinking, just with the extension of the three bringing a tribunal claim to 6 months rather than 3 months. Of course, also ACAS with the early, you've got to go to the early conciliation beforehand, but that's extended from 6 weeks early conciliation to 12 weeks early conciliation as well. So actually, employers thinking about it have got a really long period where they're waiting to see if a claim is going to fall.
Yes.
To potentially kind of 9 months ish.
Yes, exactly. So you've got this where, you know, even now you can't be entirely sure after 3 months because you have got the ACAS period and it also takes tribunals a time to process things. But you could probably say, realistically, after 6 months, if you haven't had anything land in that period, you're pretty safe to assume that you can move on from that issue. But you're right, going forward, it's going to be more like 9 months, 12 months before you can really kind of breathe that sigh of relief that that you can draw a line under those issues and that no claim is going to be forthcoming. And it kind of just to kind of that also goes to, if after 12 months something did go to tribunal, obviously you're getting further and further away from the events that have actually happened around the incidents. So it's going to be really crucial to kind of keep good documentation, notes of what's happened, get the evidence from the people involved at the time, because actually people could be moving on, easily moving on within that period, and then you might not have the kind of key people within your organisation to defend those claims.
Thank you.
Great. I think we'll call it there then. And if anybody does have any follow-up and wants to drop me an email, please do feel free. But otherwise, thank you everybody for joining.
Thanks,
Thanks,
Nicky.
Nicky.
Thanks,
Appreciate
Nicky.
it.
Nikki.